Thank you for calling the Law Office of J. Price McNamara. How can I help you?
Yeah, I received a denial letter in the mail today for my disability benefits through my employer, and it says ERISA on my denial letter. What does that mean? What is ERISA?
That's actually a great question. What is ERISA? When people get insurance denial letters, they usually have the word ERISA written somewhere within them. And it leaves people scratching their head. Well, what is ERISA? How does it affect my claim? Well, ERISA is a federal law, and it stands for Employee Retirement Income Security Act of 1974. So what? Who cares? How does it affect your claim? Well, ERISA governs, that law applies to any insurance, and that includes long-term disability, short-term disability, life insurance, accidental death insurance, and even some others that are issued or purchased through an employee benefit package through your workplace. So when a claim is governed by this federal ERISA statute, it's a totally different process. And if your claim gets denied and is governed by ERISA, you don't get to go right to court and sue the insurance company and try to get a judge or a jury to overrule the insurance company. What happens is you have to do what's called an administrative appeal, and that administrative appeal is really going back to the insurance company, asking them to reconsider their denial and telling them the reasons why they should reconsider, supporting your argument with facts, new evidence, new medical records, trying to strengthen that case. And it's only after that point in time, if they deny that administrative appeal, that you can actually bring a lawsuit against the insurance company. I go through the process of how to file a great long-term disability administrative appeal in a book that I wrote that you can download for free at winmybenefits.com if you'd like to have a look.
So under ERISA, will I ever have to go to court? What about my doctors? Will they need to speak to the court?
Well, that's another good question. Do you ever have to go to court? You are entitled upon a denial on administrative appeal to file a lawsuit. But that lawsuit goes through a process that's different than any other lawsuit really in any other area of law. You do file a lawsuit, you do go through court, but you never do go testify before a judge. You never do go testify before a jury. No witnesses come testify. Your doctor doesn't come testify. What happens instead is the administrative record that was built during that process of the claim and the administrative appeal, that record, it might be 1,000 pages long, gets filed into the court record, and it has medical records, and it has your doctor's opinions, it has your statements, it has your employer's statements, a lot of information and records that the court then considers to determine if the insurance company was correct in denying you benefits. So once that administrative record is filed in the court, then the parties, your lawyer for you and the insurance company's lawyer for the insurance company, file briefs, and the briefs are the legal arguments about why the facts and the law that applies to this case favor your position and not the insurance company's position. Once those briefs are filed, the court rules and a judgment comes down, and it's either in the insurer's favor or it's in hopefully your favor, but nobody ever goes to court and testifies. The judge doesn't ever even see you or your doctors. That's how it works. If we can ever answer a question for you, give us a call or go to winmybenefits.com. We have tons of free information. We have the book you can download on how to file a great administrative appeal, and we'd love to talk to you. Thank you for listening.